I need an accommodation this morning, so I'm going to remain seated. But I do appreciate the fact that Jefferson County invited me back, because that's always the highest compliment, I think, to have a repeat performance. How many of you are attending a Section 504 training for the first time in your professional careers? Great, welcome. And that challenges me because I want to be sure to include the basics as well as some of the current nuances of the interpretation of the statute from OCR. As Gloria said, most of you probably, I would make the assumption, are more familiar with IDEA, special education law, than you are with Section 504. And so I'm going to try to distinguish between the two of them. And in so doing, we'll do a little bit of both. However, we will delve more in detail into Section 504 because that is the focus of the workshop. And as Gloria said, it is quite different, even though we assume disabilities and special education. So we'll see where the things take us this morning. Please feel comfortable to raise your questions at any time because I know how they get away from us. I do reserve the right, however, to say we're going to get to that in just a minute and not totally miss any points by skipping around in the presentation. The first thing I want to do is to ground us in the actual federal laws of the country so that we understand how we came to this point in our development with disabilities rights. You'll see that in 1964 we had the first Civil Rights Act, and this was Title VI. We know that shortly after that, and the next year, we began the Elementary and Secondary Education Act funding. That's what ESEA is, and that's what No Child Left Behind is. Our presidents seem to like to give little catchy names to laws. It's ESEA, the Elementary and Secondary Education Act, and it gives funds to public schools. Then in '72, we had the educational amendments that were Title IX. And finally, in '73, and again in '92, we had the first Rehabilitation Act, which we know as Section 504. We're looking at that portion of the Rehab Act. Notice it was not until the next year that we got the first Educational Disabilities Law, EHEA, Education for the Handicapped Act. That was the first iteration of IDEA as we know it now. After that, we had Section 1983, and that has to deal with money damages. And it seldom comes into play in public schools, but it's a part of our history, and I wanted to share that with you. Then we have the first Americans with Disabilities Act. And that ADA was intended to take the requirements of Section 504, that we not discriminate on the basis of a disability, and move that into the public sector so that we have now curbs and newly built sidewalks. We have elevators that sound when they progress from floor to floor, addressing the disability needs of people in the general population. That's where we got our teleprompters. It's where we got our scrolls on the bottom of screens so that people who are hearing impaired can enjoy television, for instance. That's where all of this came from. And it is still growing and changing through the amendments that were passed in '09. So then we had in 2002, No Child Left Behind, which again was a reiteration of the Elementary and Secondary Education Act, a funding law. Then we have IDEA 04, which is the Individuals with Disabilities Education Act, which goes back to that very first 1974 law, which was the Education for the Handicapped Act. It's confusing sometimes because, as I say, current politicians like to have a little catchy name. And that's what Bush did with ESEA, calling it No Child Left Behind. I'm sure we will have another name whenever Congress gets around to reauthorizing this law. The Americans with Disabilities Act amendments, as Gloria said, came to us because Congress didn't like the way the courts had been interpreting the Americans with Disabilities Act. Partially it came to a head because of the returning veterans, as Gloria said, who could not seem to get services, yet had clear disabilities, post-traumatic stress disorder and other things. And they couldn't get in colleges and universities to further their training, they couldn't get supports and services, and this is one thing that brought the law to Congress's mind. There were other things. And one very specific theme that runs throughout these new amendments, as you'll see when we get into them, is the idea that courts had been too tight with their interpretation of the law, which resulted in case law, which filtered right down to school districts and other public entities who tried to make it hard to qualify as having a disability. And Congress said, that's not where we are. We want to open the doors and to enable more people, not have this very narrow bound of interpretation. And that's going to affect some things that we do in schools. Technically, the Americans with Disabilities Act did not change the regulations for Section 504 at all. Let me say that again. They did not change the regulations for implementing Section 504 at all. But our interpretation of those regulations has to be readjusted. And that's what we're going to be discussing today. This graphic is a simple representation of our student population. You'll see that in the very center, and it's not diagnostically sound, but in the very center you have Section 504 only. And many of the children that we'll be talking about today, in fact, all of the children we're talking about today, we're trying to determine whether they qualify as a Section 504 only student. Now, why that word only? 504 is a civil rights law. And under IDEA, we are also charged with protecting the civil rights of a student who is identified under IDEA. Therefore, we cannot discriminate against them either because they have a disability. So we're making the distinction. If you're under IDEA, you have an IEP, and your civil rights are protected against discrimination because of your disability. That focus encompasses Section 504 so that you do not need a 504 plan and an IEP. You only need an IEP because you have to protect the students from discrimination against a disability if they have an IEP. However, not all 504 students have an IEP. There are the 504 only students for whom you write a 504 plan. 504 only students encompass about 1% of your student population. The latest data collection information from the Office of Civil Rights indicates that IDEA and 504 students in the sample across the country that OCR reported on equal 12% of our population. Now, we've always said in public schools that IEPs should not make up more than 12%. They do in a lot of places, but that's our benchmark, that's our average. Probably a function of the sample. But 1%, 504 only, 11, 12, 13% IDEA with an IEP. I gave Gloria this report this morning on disability rights. It's just been put out by the Office for Civil Rights. And in that, they give us some of their demographics, their data collection. And OCR, the Office for Civil Rights, is charged with enforcing 504 only. And the Office of Special Education Programs in Washington is charged with enforcing IEPs. But we see that in the area of discipline, for example, I'll give you an example here, only 11% of the students were served by IDA, but 16% of the students had been expelled. That's a red flag. When you look at your district, you shouldn't have a larger percentage of your IEP students or your 504 students receiving any kind of discipline, expulsion, whatever, than the base group. They ought to be comparable. For another example, 21% of the students served under IDEA were African American, but 40% of IDEA students who were expelled were African American. You see the dissonance there? More African American students are expelled than are in the general population percentage. And that's a red flag when your survey results go in. So, as I said, I gave Gloria this report, and it can be downloaded from the Office of Civil Rights if any of you want to explore these issues a little bit further. You'll see further in our graph here in the yellow that obviously a good percentage of our students have a disability, but they don't have a plan. They don't have an IEP or a 504 plan. Why would that be? Because they don't qualify for that. The qualifying requirement under an IEP is that the disability has an adverse effect on educational performance, right? You've got to prove that adverse effect in your IEP meetings through your evaluation and so forth. In 504, it's a phrase called substantially limits. And they may have a disability, but it doesn't substantially limit their current functioning. And then finally in the blue, they don't have a current disability, so they don't have any kind of plan. But this is just a little graphic to kind of set the framework for what we're talking about today. The intent of the amendments. It wasn't amended because of anything that we in public schools were doing incorrectly. In fact, Congress and the Office of Civil Rights said, public schools are on board with this law called 504. It's not a problem. You don't need to make a great deal of changes. The focus, as we've said already, was on the returning veterans who couldn't get the health-related supports. And as we go through the law, you'll see where that section about health issues was beefed up a little bit in the law. And the other point that I made throughout is the reauthorization of the ADA emphasizes that determination of a disability should not require extensive analysis. We're accustomed to somewhat extensive analysis through IDEA. So the impact on schools, even though schools were not targeted in the reauthorization of the law, the impact on schools does require some rethinking on our part. And I'm going to give you one specific example of that right now. Your health plans. They're not necessarily 504 plans at this point, but you have a student who needs some kind of support for their health at school. It could be a wide variety of things. And so you put it in a health plan so that parents know and schools know and everybody knows exactly what's going on. Well, we in the past have not felt like that a health plan need really rose to the level of disability perhaps, and that a student just had some health needs and we just take care of it in a health plan. Let me read to you what OCR has said about this in their latest policy guidance. More students may have a disability and require evaluation to determine whether they need special education or related aids and services. This specifically addresses the need for schools to revisit health plans developed for some students. Under the amended law's broadened definition of a disability, and that's under the amended law of the ADAA, more students with conditions such as food allergies, asthma, and diabetes may now be covered by Section 504. Therefore, schools may need to examine such students' health plans to ensure that schools have met the Section 504 requirements for evaluation, placement, and procedural safeguards. Gloria Talbot has just shared with you all that you will be revisiting the health plans in your training that's coming up in more detail. A couple of points on this. Number one, you must do what this booklet tells you to do. The first issue that a hearing officer will deal with if you have a Section 504 hearing is to ask for a copy of your current manual. And if you aren't doing what's in it, you are wrong. It's just that easy. You lose. So be very, very certain that you have and you follow what's in your very own procedures in Jefferson County. And Gloria tells me that this is being revised even as we speak. So the next point that I want to make with you is the fact that there are requirements for evaluation, placement, and procedural safeguards. And we'll be itemizing these as we go through. In some cases, they are quite different from IDEA. So you'll want to be able to pull these out and identify them. So just to summarize, in one area of rethinking that is required, it's your health plans. Another area may also be your discipline procedures, and we'll talk some more about the discipline procedures as we go through today. But know that this document is what you follow, because this is your guide to Section 504. Okay, let's look at a few of the most recent ADAA requirements that are not quite as common for student programming as some other areas might be. And the first one I want to talk about is the use of service animals. This has been a wide open area in the public sector as well as in public schools. And for example, briefly, I have dealt with it as a condo association president in the U.S. Virgin Islands. And we have a no pet policy. This is the public sector, no pet policy, that's okay. But it's not okay if the individual presents with a service animal. So we've had to develop some procedures and some ways of doing that. The law tells us there are some specific definitions that need to be applied. And one of those definitions is, what is a service animal? Well, a service animal is not an elephant. A service animal is not a bunny rabbit. A service animal is a dog. And yes, in another section of the law, a service animal may be a miniature horse. I don't know of a public school that has yet been presented with a miniature horse. Horse, a miniature horse. But we're going to talk specifically about service dogs. I think that is the more likely kind of thing that you will deal with. The animal, the dog, is individually trained to work, to perform specific tasks for the person with disabilities. Service animal means any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other disability, mental disability. The crime deterrence effects of an animal's presence and the provision of emotional support, well-being, comfort, or companionship do not constitute work or tasks for the purpose of this definition. If some of you were here at this training last year, you know I cautioned you about that statement, saying, be careful about emotional support, comfort, stability, well-being, because there are some disabilities that impact those very areas. And in the first listing, you saw the word psychiatric. So we aren't to focus on what the individual's label is, or what their disability area or their major life activity area, but instead you're to focus on what work does the animal perform. There are only two questions that we can ask under this law when someone presents to us and says, I have a service animal, I want him, her, in my classroom with my student. We may ask only, is the animal required because of a disability? There's a lot of misunderstanding out there in this area. You're not asking what the disability is. Be very, very careful here. We cannot ask an individual, are you emotionally disturbed, for instance? It's not a question we can ask. You probably will know that in the public school setting because you are developing the IEP or the 504 plan. But you can't ask. That can't be a factor in determining your decision. Is the animal required because of a disability? And two, what work or task has the animal been trained to perform? That's it. That's all you can ask. And if the answer should be something like one that I got recently, well, I need protection. And the individual went on to tell me why she needed protection. It was a very valid reason. But the reason wasn't a disability under any kind of thing that I could think of. And the next problem I was dealing with was the animal was quite aggressive. You'll see there the animal must behave and be housebroken and must be basically under the control of the handler or the owner of the dog at all times. Yes, ma'am, question?
I saw online a little autistic boy who had therapy chickens.
She's presenting a situation where she saw online where a young autistic child had therapy chickens.
And somebody chopped their heads off. And not to go gruesome on anybody, but anyway, they said the chickens really worked. Of course, they would be housebroken.
Exactly, that could be a problem. This is the service animal in the public setting, okay? In your classroom or in my condo or in a restaurant down the street. And if the service animal, as in the case that I was dealing with, is very aggressive, barking and lunging at the leash when anybody walks by, that's a difficulty. And we approach the individual with that concern. And she says, oh, he won't attack unless I give the command. I said, well, they don't know that. You know, when the animal is lunging against the car window to get out and attack someone, that's a very threatening kind of thing. So the demeanor of the animal is of concern for a public classroom. And secondly, housebroken for a public classroom. We are not required to clean up after the miniature horse. That's just not expected of us in a public setting. So these are some guidelines for you. There's a very specific section in Section 50 in the Americans with Disabilities Act that defines service dogs. And I do expect there will be more cases along these lines. Terry, do you have a question?
Are the schools, needing to provide these service animals for children?
Are we required to provide the animal for service? No, we are not. We are required to allow the presence of the animal and to allow the animal to do its work. Very good question. Thank you.
Do you need to provide a handler for the animal?
No, we do not. We do not provide the handler. Under ideal circumstances, the child or the adult who has the service animal will be the handler. But that's not always the case. So remember those two questions. Now there are some court cases that have already come up, and there was one filed just recently that I'll tell you a little bit about, just to give you a framework for some of the kinds of problems that might come up. This was filed in September, and there's been no resolution to it yet. But it deals with that comfort, companionship, emotional support arena. And there is a service dog for a young lady who is now in her senior year in high school. And she's had the service dog, the same dog, since she was a freshman. And the service dog is described as alerting the student when people are trying to communicate with her and when she needs to communicate with others, alerts the student to interrupt her from anything that would be causing anxiety or the building of anxiety. And these are complications of autism. She also provides physical support, helping with range of motion problems. Now this is the description of by the mother of what the dog does, what work or task the animal has been trained to provide. The school, when they began to study the requirements under the ADAA for service animals, decided that this animal that they had allowed since the freshman year of high school, students now in their senior year, this animal would no longer be allowed because they labeled the animal as a comfort animal. My first question is, if you've got something that's working and there's not a problem, what are you doing messing with it? I don't know the outcome of this case, and we won't know for some time, no doubt. But it seems to me that there had been no questions or problems raised with the animal for 3 years. Why are you going to try to make a federal case out of it in the kid's senior year in high school? That's just setting yourself up to be a test case. And if you want to go to court and you want to have Gloria deal with these issues, that's just not something that seems to be a valid approach for the school district, particularly when there hadn't been any problems. Also, they said that the student was identified under the category of attention deficit disorder, and that she wasn't identified as having an emotional disturbance, so she shouldn't need support for that. Remember, we don't ask. and you block out the fact that you even know what the disability of the child is, you're dealing with the animal and the task the animal is trained to provide, and the impact that the animal has on the classroom. So those are the areas that we need to be concerned with when you're dealing with service animals. There are several public access issues in the law that may or may not impact you in the public school setting. You may have power-driven mobility devices. I needed to use one of those recently, folks, and they're flat out wonderful, so don't knock it. Accessible and companion seating at events. You know, you go in many theaters and you have a row where there's one seat omitted at the end so that the wheelchair can fit right in and not be sticking out in the aisle. And we are required to offer that kind of a seating when appropriate for students or anyone in wheelchairs. And they are required to have a companion with them. They're not required to have it, but if they do have a companion with them, we must provide seating for that companion with the person in the wheelchair. For schools, it's particularly important that there be an unobstructed path of travel and a line of sight to where you're going in assembly areas so that the individual in a wheelchair or whatever mobility device can see where they're going and have a direct way to get there without weaving in and out of rows and so on and so forth. And the use of interpreters. I'll just give you one area to be really aware of in this, and that is in public schools, if you have identified as a child as disabled, either under IDEA or Section 504, and that child has a parent who has need of an interpreter, we must provide it. Now, let's get this distinction in mind. If the child is not a child with a disability, but the child's parent is, for example, hearing impaired, and the child is participating in a ceremony or activity, or you have a parent conference at school or whatever, centered on the needs of their particular child, you must provide the interpreter for the parent. And this interpreter cannot be paid for out of IDEA funds because the student doesn't have an IEP. And of course, there are no funds to pay for them out of a 504 student's needs. That is a district responsibility. Once again, the individual student does not have any kind of disability. But the child is, for example, participating in honors night and receiving an award. That parent of the child, who is hearing impaired or mobility impaired or whatever the case may be, is entitled to have their needs met through an interpreter so that they can participate in the educational experiences of their child. I'm sure you've noticed that, and I don't know this for a fact, but I'm sure you do, Gloria, you have interpreters available for public board meetings and things like that that the education district provides. This is a part of the ADA and making our public activities accessible to parents. And I have a little cartoon that I just love that illustrates this, Gloria. It shows the janitor workman out front of school clearing the steps of the ice and snow, and there's some students standing there to go up the steps, and there's a little boy in a wheelchair. And he says, the little boy, the caption says from the little boy says, "Excuse me, sir, if you'd clear the ramp, we could all get in." I love that one.
Can I ask a question, please?
Yes, question, where is that?
Up here. Does the parent, in the situation you just explained, does the parent need to notify the school staff?
Yes, Very good point.
Reasonable amount of time that's provided.
Yeah, very good point. If the student is participating in honors night, for example, and you wouldn't normally have interpreters present, it is incumbent upon the parent to say, I need this support. That simply means that you need to be aware of it. After a period of time, you would know that.
Right.
But you need some notice to provide this kind of thing. Most school districts do it automatically for their public board meetings and things like that. I used to work in a school district that were, their administrative offices were in a very old nursing home, actually. And the only conference room in the building was on the third floor, which is where my offices were. And needless to say, there was no elevator. And when I first went to the district, especially as director, I began holding parent advisory council meetings. And it opened it up to any parents in the district that wanted to join, and sent them invitations, and it was scheduled for my third floor conference room. And somewhere in all of that process, it dawned on me, third floor. You're holding a meeting that's open to all parents in an inaccessible location. And fortunately, by that time, we'd built our 3 new middle schools that were all one level, so I just transferred those meetings to start having them at one of the middle schools, because I didn't know that a parent might not be mobile and able to climb those stairs. But if I was notified, there wasn't a thing I could do about it. So I just set up my location to begin with to avoid that problem. The law. That's all there is in the law. One statement, Section 504. And beginning here, we're probably going to be spending more time talking about Section 504 only, with only occasional references back to IDEA. But this is the law. IDEA, is, quite hefty. But we have one long sentence. No otherwise qualified individual with disabilities in the United States shall, solely by reason of the disability, be excluded from participation in, denied benefits of, or subjected to discrimination under any program or activity receiving federal financial assistance. Okay, let's break it down and see what that means. Otherwise qualified. You're talking about public school. If you got a 2-year-old child, they're not otherwise qualified to be in public school. They don't get to come just because they have a disability. They have to be qualified. Honor Society. You have a student with a 504 plan who is making excellent grades and qualifies for the Honor Society. But hey, the Honor Society is for kids that make good grades and don't have any problems. So maybe she's getting some extra help on that 504 plan that enables her to make those good grades, so she can't be in the Honor Society. No. If your criteria for the Honor Society is making A's and B's in all classes, and she's making A's and B's in all classes, you can't even consider that IEP or that 504 plan. She's making A's and B's, she's in the Honor Society. Now, if she's a freshman, and the criteria for being in the Honor Society is juniors and seniors with A's and B's, she doesn't get to be in the Honor Society because she has a disability. You have to be otherwise qualified and meet the standards for the program. Can you add to the standards of the program and you can't have a disability? Juniors and seniors with no disability who make A's and B's could be in the Honor Society? No, you cannot. Okay, solely by reason of the disability. There's been myriad court cases where parents have said, they didn't let my daughter be a cheerleader because she has attention deficit and has an IEP or a 504 plan. And nearly all of those cases have been denied. because schools were able to show, well, we have this criteria for being a cheerleader. And part of that criteria is passing grades, and another part of it is good sportsmanship, and another part of it is some measure of athletic ability so they can do the cheers. And we have a panel that interviews these kids, and we also take teacher recommendation about good attitudes and good sportsmanship. And your daughter didn't meet that criteria. So you don't get to do something just because you have a disability. You have to be otherwise qualified, and that's the only exception there. Discrimination. Well, one other point let me make. Federal financial assistance. Schools definitely get federal financial assistance. So in any area of your programming, in any area, extracurricular, after-school activities, field trips, any area of public education, you must not discriminate because of a disability. That means, folks, that you can't require mom of the student who has temper tantrums, acting out, running away, and has an IEP or a 504 plan. You can't require mom to go, or the kid can't go. If you need an aide or a paraprofessional for that child to participate in the field trip, you provide it. I had a situation one time of a little girl who had had some pretty severe surgeries and was coming back to school in a wheelchair. It was somewhat temporary, but there were going to be a series of surgeries. And we certainly could put her on a bus with a lift without any difficulty, but her school building was a very old building, and there were no elevators, and there were stairs. And we couldn't relocate the cafeteria from the basement level up to the ground level where the child could enter. We couldn't adjust programming or location of sites. So what we finally did in that circumstance was to temporarily transfer the child to another nearby school that was fully accessible. That was not a good solution, but it was the only one we could make. We had another child whose parent did not want her child in a wheelchair being transported on the little bus with the lift for field trips when all the other kids got to ride the big bus. And she wanted us to just lift the child out of the wheelchair and sit her on a seat, put the wheelchair in the back of the bus. Well, you know, that's not safety. You can't do that. So we puzzled over that for a while, and we finally, and I think it was one of the child's friends that even made the suggestion to the young lady in the wheelchair, well, why don't some of us just get to ride your bus? Hey, all right. So we let the individual student choose however many would hold, the little bus would hold, so many of her friends who got to ride on the bus with her. And everybody was happy. And you know, that's the key. Let's keep things working and keep folks pleased with what we're doing. Yes, ma'am, question?
Would you repeat that comment you made about not asking parents to go on field trips again and explain it?
I used the wrong word. I didn't say not asking. I meant to say not requiring. You cannot require a parent to accompany a child on a field trip for supervision or support that you would provide within the school building. In other words, you've got to provide the aid.
For any child under 504 or for any child, what do you, I'm not
Sure.
understanding.
A child with a disability cannot be denied the right to go on a field trip simply because they need additional support of some kind.
I understand.
Got it. And another example of that, Gloria, is free lunch. Many of our students have free or reduced cost lunch at school. And let's say that you're taking your classroom of students, perhaps it's a special education classroom, whatever, on a community-based instruction class, or they're going to be away from school at lunch, and part of their programming is ordering lunch at McDonald's or something like this. The school has to pay for that. You can't ask the student who is entitled to a free lunch at school to pay for it as part of his instruction somewhere else in another setting. So these are just things to be aware of, and as Gloria's saying, if you get into a situation where you need assistance on that, there are procedures that the district has, and seek those out from her office if you need additional guidance on that kind of thing. So the purpose of Section 504 is civil rights legislation. It is not education. It is civil rights, protection from discrimination within the educational program. You sometimes may find that you have to stop your thinking and realize that for Section 504 implementation, your school district does not get any additional funds, as you do with IDEA. With Section 504, just because we get federal dollars, we have to implement this law and be certain that we do not discriminate. So there are some costs, as we've already discussed, that the school system must simply assume, because we do get that pocket of federal dollars. But you do not get additional funds for this. Don't call Gloria and say, you need to pay for this interpreter that I've got coming to this meeting for this parent. School budget. The legislative intent of this whole concept of Section 504 is to prevent discrimination based on a disability. Let's put this in the framework of all civil rights laws. Back through probably the early 90s, the only real thing school districts were doing with Section 504 was that we had a grievance officer, and we had a little statement on the bottom of our stationery that says we do not discriminate on the basis of. What were all those things down there that you can't discriminate on the basis of? Race, religion, age. I'm getting there, age. All these kinds of things. And disability is one of those. So before the early 90s, we played the compliance game in public schools and said we don't do that. But it took an issue on the national front to wake us up to the fact that perhaps we needed to do more. Some of you in this room may have been in public education in the early 90s, late 80s. And if you were, you didn't know anything about 504 plans. You weren't writing 504 plans. You had that statement on the stationery and you wrote IEPs. In the early 90s, there was a parent group, a very active parent group, that petitioned Congress in Washington to add the label attention deficit hyperactivity disorder to one of the categories of IDEA. And at that time, I was policy and legislative chair for a national group and working in special education. And those of us who were in the field there became horrified at the thought of that happening, because we could see where it was going. We'd have doctors writing on a prescription pad, he's got attention deficit disorder, put him in special ed. And so we presented to Congress the fact that many of students who were considered to be attention deficit disorder were already identified under IDEA. Maybe they were identified as learning disabled. Maybe they were identified as emotionally disturbed. Maybe they were identified in some arena, health impaired. So we didn't need that specific a category added to the law. Well, long story short, they agreed with us, but there came out a letter of policy guidance to public schools from the OSEP and Office of Special Education Programs, from the Department of Education, Office of Rehabilitation. And in that letter, they were attempting to explain why they did not put attention deficit disorder in the federal law of IDEA in a separate category. And they used the arguments that some of us had presented. Well, you know, if the student is severe and has a adverse effect on the educational performance, they're already identified as learning disabled or emotionally disturbed or whatever. But then the letter went on to say, but don't forget, folks, they may also be eligible for services under Section 504 of the Rehabilitation Act. And we said, under what? Because the country wasn't doing anything with that law, with Section 504. And so I'll go one step farther here just to share a resource with you that's listed at the end of the presentation. The Council of Administrators of Special Education, the national organization that I was working with at the time, put together the first little booklet called Section 504, a resource guide for educators. And it kind of walks folks through what this meant. And we began to see the concept of an actual 504 plan taking place in public schools. This is the 4th edition of that little book, and it includes the ADA and amendments now if you want something like that for a resource for your school district. Let me just emphasize that Section 504 is not an education law. It is a civil rights law. And your focus in developing a plan is not on education, it's not on learning, but it's on any major life activity that the individual may be experiencing, and you must take into account in order to prevent discrimination. So, what is discrimination? Discrimination is a negative, keeping people out, whether figuratively or literally. It is saying we've got these kinds of services, we've got these kinds of things happening, but you can't do it. And you can't do it because of your disability. You can't deny participation or benefit from services that everybody else is getting. And that extends even to areas and arenas that you support outside the school day. For a quick example there, let's say that your school building hosts a community education program that's an after-school program, after school. And any of your students are able to set up an arrangement for the student to remain in that program after school for a couple of hours while the parents get off work or whatever the case may be. Same situation as that field trip. That program that you support and allow it to be in your building cannot discriminate. And so if one of your students wants to participate in that program, they must be provided the same supports and services that you give them during the school day, such as a para, mobility access, whatever it might be. And that program cannot charge them extra for providing that service. They have to agree that they are a non-discriminatory program in order to operate in your building. There's a long list of, well, it's not too long, but as a list, it's more extensive than this, of evidences in the 504 regulations, evidences of discrimination. And those are listed in this little booklet, so you can reference that for the full list at any time. Here's some of them. Equal access and opportunity to participate, equally effective aids, benefits, services, enjoyment of rights, advantages enjoyed by others, opportunity to participate. And then finally, the last example is the one that I gave you and we discussed briefly. Perpetuates discrimination by assisting another agency that discriminates. And finally, those last two words, hostile environment. We're hearing a lot about that these days, usually in the context of what we generically call bullying. But this is a very difficult environment in a public school building or classroom. Here's the criteria or the standards for dealing with harassment because of a disability, or for any reason for that matter, or what is called a hostile environment. The school knows about it or reasonably should know about it.
No.
There should be an immediate and appropriate investigation. We must be proactive and take prompt and effective steps to end harassment, prevent its recurrence, eliminate any hostile environment. This does not mean simply putting the child in another classroom if there are bullies in one classroom that he's in. We can't just punish, discriminate against the individual who's experiencing this environment. You have to take it to the perpetrators of the environment. And the definition of a hostile environment is that the harassment is sufficiently severe, pervasive, or persistent to inhibit the student's participation, benefits, or opportunity. We all know about the concept of sexual harassment, particularly in the workplace. This is the translation into the school setting because of a disability. This arena, if you get into difficulties here, it's not only a 504 violation because you're allowing this discrimination, but it's also a violation of FAPE. And many of the court cases are proceeding along that line, showing that the student cannot get an appropriate education in this classroom because of this harassment, this bullying, because of a disability. Those of you who might be members of the Council of Administrators of Special Education will find in one of the recent newsletters a very good checklist regarding the steps for a school district to take in terms of harassment. And you might want to seek that out as a resource. So let's see about these basic requirements of Section 504. Eligible students will receive a free and appropriate public education, and they're educated with non-disabled students to the maximum extent appropriate. Sounds familiar, doesn't it? Schools shall seek to identify and serve all students who need services. Ooh, sounds like child find to me. Evaluation procedures are appropriate and avoid misclassification. Procedural safeguards are utilized. Sounds like some of the same language for IDEA, doesn't it, in special education? But it's different. One arena that I haven't talked about that comes to mind here is the idea that of FAPE. And we'll see that FAPE is different under Section 504 than it is under IDEA. We'll talk more about that in just a minute, but we'll see that there are differences as we go through these things. Yes, we seek to identify and serve all students who need service. And we know that there are child find requirements under IDEA, and someone in your district is responsible for posting those requirements yearly and getting an article in the newspaper and that kind of thing, that we're in search of children who might meet these criteria, and please call your local school district, whatever. I always wrapped my 504 into that child find announcement rather than making a separate public announcement for it. It's quite satisfactory. You can say something like children with disabilities who might be eligible under either the Individuals with Disabilities Education Act or Section 504 of the Rehab Act, and that suffices for your child find. Those kinds of notices should be up in your school at least once a year and that kind of thing. Many places just keep it up all year long on the bulletin board. Evaluation procedures are appropriate and avoid misclassification. Let me just quickly say here, evaluation is different. Under IDEA, we pretty well know you got to do this, 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 and this. You got to have a social and developmental history. You got to have this. You got to do an intellectual assessment. You got to do these things for these disabilities. Pretty well prescribed for you. We don't have that under 504. Under 504, you have to do an appropriate evaluation, but it depends on what you're looking at in terms of your major life activity and your substantial limitation. So there's no set rules for what you have to do. The only rule is do whatever is appropriate and necessary to address all areas of the suspected disability. So little more judgment, decision-making required of you as individuals on a team in a local school district when you're dealing with 504. We will have some more examples of evaluation as we go along, but let me just say, you're not looking at education only under this law. IDEA is an education law, an instruction law. This is major life activity areas, anything that an individual does. And we're going to have more detail on that in just a few minutes. Let me also say another example here. Procedural safeguards are utilized, and they are different. There is nothing in the 504 law or regulations that requires parent attendance or invitation to attend a 504 meeting. But I don't know of a school district in the country that doesn't have that provided for in your 504 policy manual. We're not going to deny parents the right to participate in this. It doesn't make sense to us as public educators. But it's not required in the law, but it's in here, I guarantee you, so you've got to do that. Civil Rights Act and IDEA. Here's the difference that we're talking about. This is why you don't need to do all those set educational evaluations necessarily. You may not. 504 is protection from discrimination. IDEA is instruction. Our goal under IDEA is to prepare for independent living and work. That's the focus of the public school education. 504 is looking at protection from discrimination. There are very specific disability categories under IDEA. Under 504, my good friend Perry Zerkel talks about 504 or more impairments or disabilities. The standard under the civil rights law is a substantial limitation of a major life activity, and we're going to spend a whole lot more time on that. Under IDEA, you know it's adverse effect. And not only do they have to have one of those specific educational disabilities under IDEA, you got to prove it's an adverse effect on their educational performance. Under 504, it's a substantial limitation of a major life activity. Section 504 is regular ed, section IDEA is special ed. Now, the words special education are in section 504. But remember, we got section 504 first in the time frame. And then special education through IDEA came along and layered on top of it. So we generally conceive of regular education as the implementer for section 504 plans. And FAPE, under civil rights law, look at the difference between those two. Appropriate means meet the needs of the student as well as you meet the needs of the non-disabled in your classroom or building. FAPE means instruction under IDEA, two very different categories. Here we go. Is there a difference? Yeah, because under 504 we're looking at a lot of other arenas rather than education alone. So what is special education under 504? It's there. It's a decision that you make in your evaluation and program planning for the child in conformance with all the other federal and local laws, which means, and which is usually interpreted nearly 100% of the time, that if the student qualifies under IDEA as having an educational disability and in need of special education and related services, they will be served under IDEA. And the court cases go so far as to say, and the parent doesn't have a right to say, I don't want an IEP, I want a 504 plan. I've had a few parents that requested that, and as I sat down and met with them, I learned that what they really wanted was that their child not be pulled out and go down the hall to another classroom. Or they didn't want their child being put on that little bus. And as you talk about planning and meeting the needs of the child, those issues can be removed and still keep special education on the table. And for many reasons, if the child has an educational disability, you want to serve them under IDEA because they get instruction, and that's their need. So here's that list of procedural requirements. You see the same kinds of things we're accustomed to under IDEA, but as I said, they are very different. And as we talked about a minute ago, how do you define appropriate? Well, under 504, it's an education designed to meet the individual needs of the disabled as adequately as the needs of the non-disabled are met. No discrimination, no differences, equal opportunity and equal access. And under IDEA, appropriate means benefit, educational benefit. That's not our goal under 504. Under 504, the goal is equal treatment under the law. The same programming access as everybody else gets. So let's look at some specific definitions and determination under Section 504. Here's the definition of an individual with disabilities. They have a physical or a mental impairment. You frequently hear the phrase, the three prongs of Section 504. The first one is the physical or mental impairment, and that's defined as any physiological disorder or any mental or physical disorder. Pretty broad. It's not those 13 categories under IDEA. It's the ballpark. Or, and these last two prongs of Section 504 rarely come to bear in public schools, but they do occasionally. They have a record of an impairment. Let's see what that might be in our educational world. First thing I can think of is the many, many children who are released from IDEA. You know, there are a few. But particularly, I think about speech language. Most of your children receiving services under an IEP in the category of speech language or communication disorders, however it's labeled right now, most of those kids are in the early grades. And they reach a plateau. Either their enunciation problems are solved or their fluency problems have been addressed, and they no longer need those services, or the decision is made that they've reached the level that they're going to reach. They're going to continue to have a slight enunciation problem, but that's acceptable. And so we release them from special education. We terminate an IEP by doing an evaluation, having a meeting. They're no longer eligible under IDEA. Next question comes up. They have a record of an impairment, so are they automatically moved from an IEP to a 504 plan? No. Nothing in 504 or special ed is automatic. Just get that phrase out of your mind. It's not there. Should you consider? Yes. There should be a process in your IEP meetings when a child is being released from service that you also consider the fact, based on that evaluation that you've just completed to release them from an IEP, consider the fact of whether they need a 504 plan, whether they're eligible. But it is not automatic, and in most cases it is not done because the needs presented by the disability have been appropriately addressed. Regarded as having an impairment. This usually comes up in the work sector, very seldom in schools. But I'll give you an example. Football player has a concussion in a game on Friday night. It's a pretty bad one. Under some medical care, goes to the hospital. Comes back in a week, wants to play football again. But the coach says, golly, I don't think you're ready yet. You're going to have to sit on the sidelines for a while. That coach thinks he has a disability. He thinks he has a medical problem, and he is denying the kid the ability to play based on what he's thinking. That's discrimination on the basis of the coach's suspected feeling about the child's ability. And that is discrimination. Most school districts get around this problem and address the whole issue simply by requiring what? A doctor's statement to return to football. And then nobody's making a judgment other than the medical physician who is qualified to make a judgment. More on record of or regarded as. Again, these two categories of that 504 disability seldom are paramount in public schools. So what is a major life activity? We've used the phrase, the standard under Section 504 is substantial limitation of a major life activity. What is that? First, some caveats from the AD, Americans with Disabilities Amendments. And that is, don't assume that because the kid's making good grades, he's not going to have any kind of a disability area under Section 504. Or IDEA, for that matter. But good grades aren't the standard. You've got to go beyond that. You've also got to think about other kinds of things. Each area is a major life activity, and we'll see what those are listed under the law. The term includes those things, those basic activities that the average person in the general population can perform with little or more difficulty. This is the first occasion that I'm going to say to you the comparison base for Section 504 is not how well I can do, it's how well I can do compared to everybody else in the general population. In my normative group, obviously, I'm not going to be compared to a 20-year-old. So, these are major life activities. Caring for myself, manual tasks, walking, seeing, breathing, speaking, learning, working. It's not all-inclusive. There are constantly other areas coming up. And the ADA added for us in January 1 of 2009, reading, concentrating, thinking, communicating. Ooh, these sounds like school things, don't they? Eating, sleeping, walking, standing, lifting. Many of these come out of court cases that then bring the terminology into the law. And added also in 2009 was this area of major bodily functions. And this goes directly back to those returning veterans that we mentioned earlier on that brought this need to Congress to revitalize and reauthorize the ADA. They expanded the scope of major life activities under the law.
When you write a final goal plan for a child that's diabetic, you think, well, this sounds bigger is a major life activity. A lot of times, nurse practitioners will help you with that, but a lot of times the terminology that I see on the reports are things like all global bodily functions or major bodily functions. Same thing with sickle cell kids. A lot of times with youngsters who have the physical impairments, it's not just one thing, it's the whole one acts upon another. So they'll help you write the major life activity. But if it's, and you'll get to that part. When you write, identify the major life activity, remember, that's going to dictate what your accommodation's going to look like. We'll get to that.
Question?
What if there's a student who has a urinary issue, is medically diagnosed, they're receiving disability benefits for it, and because they have this issue, they miss out on learning because they have to go to the restroom so often, would that substantiate a 504?
I didn't understand the last part of your question. The individual has an area for which they're receiving disability support payments.
And because she has this impairment or disability, she does miss educational or learning opportunities because she has to go to the restroom so often.
Okay. And this individual that you're talking about either has to, and we can just expand the example, either is absent from school frequently because of their disability or has to leave the classroom frequently to attend to personal needs. Certainly, it seems from what you've described that an individual in that category would have a disability. You may be asking about what kind of accommodations would be necessary, and we will make them. For example, she will not be required to limit her trips to the bathroom to when the entire class goes. If she needs other arrangements, they will be made. Frequently, students may have health issues and disability issues that require them to be absent from school quite a bit. And that will be excused absences. And that gets to be a difficult problem for the principal, who is required to be accountable for the attendance in his building. And I know many principals set up, particularly in elementary schools, they set up rewards programs for the class that has no absences for the month or something like this. And yet there's a little boy in the classroom who has, let's say, emotional issues, and the therapist that he sees weekly, 1 week out of a month, can only see him during school hours. And the rest of the time he goes after school, but, you know, occasionally those appointments are required to be during school hours. If that's the case, the entire class cannot be punished, if you will, for his absence. And you know what you do? You adjust the school policy on that. Wow! What you need to do is to say that if that is the only absence in that classroom for that week, then the class is rewarded for perfect attendance. If anybody else is absent, or if he's absent for some reason that has nothing to do with his medical appointments, then they lose. But we, on occasion, through an IEP or a 504 plan for that matter, can substantially adjust school policy to meet the needs of the disabled. We've discussed the fact that the standard for Section 504 eligibility is a substantial limitation of a major life activity. We've given you a ballpark reference of what major life activities are. What does substantially limits mean? Well, there's no clear-cut definition. Are you surprised? The impairment must substantially limit a major life activity, not just learning, not just education, but any part of those major life activities that the average person in the general population can easily perform. Remember, the comparison base is always everybody else out there. It is not me. It is not, I used to run a 4-minute mile and now it takes me 15 minutes. So there must be something wrong, so I have a disability. No. The average person in the general population does not run a 4-minute mile. Are you unable to perform the activity, such as sitting and standing? Or are you substantially limited in that? That's the criteria. Substantially limits is your decision. I'll say this again. Substantially limits is your decision. The school 504 team. You have to make that call based on the evaluation that you have done of the child. And you follow your district procedures in making that decision. This goes back to that evaluation question we had earlier. What do we have to do to evaluate the child? Here are some of the things that you can do. And here's your standard. The evaluation materials must document the performance of the child in school. And performance does not mean educational performance. It means, here I am, what can I do? That is caused by an impairment or a disability. And it's substantially less than the performance of the average student in the general population at school. So, what do you look at? The things that reflect the child's performance. Report cards. Norm reference assessments if you're looking at a learning problem. Curriculum-based, structured interventions of some kind. Social health history, medical reports, anything else that you think would give you more and additional information about the child. And do you consider what the parent brings in? Absolutely, but you cannot require them to give you anything. If it's a medical situation, you may have to, with parents' permission, contact the doctor and get the assessments that are necessary, just as you do under IDEA. Again, we're comparing to the average student in the general population. I was sharing an example a minute ago. Had a middle school that was a feeder school for half a dozen elementaries. And it seemed like every fall we got an inordinate amount of special education referrals. And as I began to examine what was going on, most of those education referrals were coming from students who had all attended the same elementary school. And what was happening was that comparison-based mindset of the teacher who in the elementary school saw students all functioning about the same level, low income, low opportunity students. But when they got to the high school, the comparison base of that teacher was more narrow. And so those students stood out as different from the norm in her classroom. That did not mean the child was or was not eligible, but it was a pattern that we needed to be aware of when we examined and evaluated each individual child. Do keep in mind that problems occur for more reasons than a disability. And that was what was being seen in that particular classroom. Cultural, environmental, economic factors, English language learners, substance abuse, divorce, abuse, other kinds of family problems, all of these can manifest themselves in performance difficulties in the public classroom. And not everything can be solved by trying to fit into a disability label. That, again, is a portion of your evaluation to sort through those difficulties. As I said earlier, substantially limits is a term that's not really defined anywhere. It's one of those terms that says, well, it's not this, but you figure out what it is. And there were two concepts that changed in our implementation of Section 504 based on the Americans with Disabilities Act amendments. One is the interpretation of this phrase, mitigating circumstances. That's not in the law anywhere. It's a phrase that came to us from courts, actually. And remember, Congress didn't like what the courts were doing, and that's why they amended the law. And this is one piece that they amended. Mitigating measures are not to be considered in determining whether a student has a physical or mental impairment under Section 504. So what does that mean? That means if you have a student who is on Ritalin because of attention deficit disorder, you don't have any of that like that, do you? And the medication is working, and when they're taking the medication, they are on task, focused, and performing well in the classroom. You cannot assume that therefore they do not have a disability under Section 504. Because we are told by the ADAA that you can't consider that Ritalin when making the determination about whether a disability is present. Now, does this mean that you don't let the child take his Ritalin for a while and see what he's like? No, please don't. Please do not do that. But you have to make an informed decision in your team meeting as to whether a disability is present without the mitigating circumstances in play. And what are mitigating circumstances, mitigating measures? The law does provide a non-exhaustive list of things, and that is medication, medical supplies, low vision devices with the exception of glasses, prosthetics, hearing aids and cochlear implants, mobility devices, on and on and on. You must consider what the child would be like and how he would present without those measures. And that's very, very difficult to do. The best you can do is make an informed judgment based on your evaluation results that you have gotten. We're also told that an impairment that is episodic or in remission can still be a disability if it would substantially limit the individual when it were active. I think personally that came from the history of AIDS in our country. Because we know that AIDS can be in remission for any number of months and years. But the individual still has the disability, even though it is in remission or episodic. Now that's going to present us some problems, the whole concept of mitigating measures, but we'll figure out some ways to deal with that, hopefully. So you don't consider these things. Glasses is one exception because they are so common in the population. I look around the room and I see many of you wearing glasses, as I do. Can you discriminate against a child because of their glasses? Yes, you can if you're not careful. I can't read my notes, and I really can't see the screen right now without my glasses. But I put them on and I'm fine. Say we have a young teenager in the classroom. You've been talking about the big exam coming up for weeks and prepping the students and so on and so forth. And on the day of the exam, after he gets to school, he breaks his glasses. Happens. Was it intentional? Maybe. But it's a reality. And if I require that young man, you knew the test was today, you're going to take that test. And I require him to take that test without his glasses, I am setting him up for failure, and I am discriminating against him. What can I do? I can make accommodations on the spot. I can postpone the test. We can call his parents and see if he can get another pair of glasses, but I can't require him to take the test, regardless of his motivation in having those glasses broken. Again, emphasizing the point that the medication may alleviate the symptoms, but you still have to determine through an evaluation whether he has a disability or not. Now, let's say you have your 5014 meeting and you decide that there is a disability present and it rises to the level of a substantial limitation if he were not on medication. But he doesn't have any problems right now because he's on medication. What are you going to do with the 504 plan? You don't have any accommodations to put in it because none are needed at this point in time. What record in your school is going to identify that student as being a student with a disability and entitled to protections from discrimination because of that disability? What record is going to say that in your school building? You don't need a 504 plan. You don't have any accommodations to write.
Our form has a thing that says, meets eligibility under section 504, but no accommodations are needed.
Exactly. You put that caveat on your plan. You say, this is an individual with a disability. But at this time, no accommodations are required. Now, whether you call that a 504 plan or there should be some kind of record that stipulates that, because specifically the area of discipline. Let's say that same individual who doesn't really have any kind of designation as a student with a disability in your building, for some reason or another doesn't have, doesn't take, doesn't get his medication that day, and there's a discipline problem, and he decks the principal. Oops, that's a no-no. But you should have something in your system that triggers the need for a manifestation determination on this child because he's a child with a disability. And in that review, you would discover that he had not received his medication. And therefore, his inappropriate behavior was a result of not getting the support that he needed to ameliorate his disability. So you need something in place to tell you that you have made the determination that this is a child with a disability. And folks, what that also says to you is you have to consider it to begin with. There is no presenting problem as such other than the child is on medication or has some of these other mitigating measures in place. There's a question in the back of the room.
Yes, what do you do for that child who's on medication and you know that he's got a disability? You have the 504 plan, but at the time, on the medication, may not need the accommodations, but for the end of the month, they're off their meds for a week or two. When they would need accommodations, because it's a cycle of them being on and off the meds, is there something you can put in the 504 that addresses those times when they're not on their?
Yeah, her question is, if you have a student who's on medication, can you build in accommodations for when you can anticipate he's not going to be on them for various reasons? Sometimes children are off their meds. You can handle that the same way you handle the situation of the home instruction. Yes. When he needs accommodations, this is what he needs. And allow your classroom teachers to implement those immediately. Something I would also do on that kind of thing, because I know sporadically kids get away from home for various reasons without their meds. One thing I usually tried to do was to get parent permission to contact the doctor, and you should have that as a part of your evaluation anyway, and perhaps you indicate to the doctor, you're not talking about meds, you're talking about school procedures. You simply say, I want to make you aware of the fact that if you want, if it seems appropriate to you, the school can't administer the medication. Sometimes that will address the issue of what's going on at home in terms of a kid getting away without it. And certainly that's one thing, one service that we can offer to anyone, and making the physician aware of that, and also being able to tell the physician behaviors and so forth of the child at school, whether on or off the meds, so that you can report back what you're seeing at school. And this is a frequent assistance to the parent and the child. Of course, you have to get permission to do that first. You must also be very, very careful that your school policies are followed. Example, had a young man who had moved from one of our middle school settings into the high school. And a couple of weeks into the month, he came to my attention for a board hearing, disciplinary hearing. And the young man had been in our district forever and had no disciplinary background and problems, and we began looking into the situation, but didn't see any reason for this in records. And that night at the board meeting, mother presented saying, you know, he shouldn't have done that. What he did was to hit the principal. He said, he shouldn't have done that. I understand that completely, but you know, he didn't get his medication. And our superintendent leaned across the table and he said, ma'am, would you tell me a little bit more about not getting his medication? And it seemed that when the young man went from middle school to high school, the high school had a policy of the school secretary keeping the kids' meds in the office. And she told the young man that he should be responsible for coming to her to request his medication. Excuse me? She didn't follow up when he didn't come. She didn't check to see that he wasn't on the absentee list when he didn't come. He didn't come, so he wasn't being responsible, so he didn't get his meds. No, we apologized profusely, and the family went home with no disciplinary action because that young man's behavior had been obviously directly related to the fact that he did not get his medication at school as was required. And the school secretary kept her job, but there was quite a scene the next morning at the building when the superintendent went out to discuss the whole process with her. So your school policies for administering medication would have covered that situation, whether there had been a plan or not. And obviously, if the kid had been on a 504 plan at that time, this was years ago, we had no record of the fact that he was getting medication at school at the central office, so I didn't pick up on it until we began to further look into the situation.
Pat made a good point with the transition from middle to high. When the kids transition from elementary to middle, and then from middle to high, I send a list out to the principals in August of students that are on the class list. I resend the list out, as you all probably worked on it recently. I send a list out at the end of the month in August. These are the students who have been identified as being in your building. You can't plead, I didn't know, I don't have a 504 plan. It's our responsibility to secure it. Sometimes I have some on file. A lot of times I don't. My documentation is only as good as what you send me. So if that youngster's name is on that list, and the youngster has a 504 plan, my list just flags it for you, okay? Make sure you have the 504 plan in your hand. Your teachers have it also, and you understand what your obligations are. It's not unusual that one was identified as a 3rd grader, they're now going to 6th grade, and you want to use the same 504 plan. That doesn't fly. The same thing happens, they did it in 5th grade before they went to middle school. Nobody ever touched it through middle school, and now they're sitting in high school. So when the youngsters appear in your building for the first time, the best practice is to look at that 504 plan, because you're obligating yourself to what's in it. And if you have failed to amend it, failed to address it, they come back on you. And sometimes plans can be real creative when the school knows Johnny's leaving us, going over here, so we'll just give him everything we thought he should have had, because they're going to have to do it. So make sure that you are very aware of what's in the 504 plan and that they are followed. If it doesn't fit your program, if it doesn't fit the youngster, we change every hour on the hour. Revisit, have your meeting. High schools have a lot of kids. I know some of them have 18 and 20 kids. But a lot of the elementary schools have 1 or 2. It doesn't take a long time, and it will help you when issues come up. Yes, we had the meeting. Yes, the plan is current. And we did it because they progressed from grade 5 to grade 6 or grade 8 to grade 9.
Yes, there's a question in the back.
I have a question in thinking about transition from one level to another. What is your thoughts about child is currently doing okay in your building? How the parent is already thinking about the child in elementary or the middle and wants something in place just in case, or because they've had heard rumors about what middle school will look like?
Okay, we're talking about that child who's transitioning from elementary to middle or middle to high, and the current educational situation has gone quite well, and we all know that middle school elementary teachers kind of go above and beyond on doing a lot of supports and services for children and provide a wonderful educational setting, and that is as it should be. And mother starts getting concerned about the child leaving the one classroom and going into middle school where they have to change classes all day, and nobody's going to really care about them like they do here. And so let's give me a 504 plan. I don't think so. There is no current disability. There is no current substantial limitation, and we'll talk about more about this recently, but that's called kind of crystal balling. And no, that does not take care of the problem. If the parent wants something in place, write a letter and say, these supports and services have worked well for Johnny in our setting. I wanted to share them with you. But don't wrap it up in legal terminology without doing a full evaluation and all of these kinds of supports and services that we're talking about. The eligibility decision process. Let's look through this. We begin with the problem, except of course in those cases where there are mitigating circumstances that confuse and hide the problem, and then you have to look further into the situation. You identify the presence of the impairment or disability. It must substantially limit a major life activity. The actual presence of the impairment or the disability, let's say you've decided on one, but you can't find any limitation for whatever the reason. There is not an automatic requirement for a 504 plan without the need for us, without the obvious substantial limitation. But as we've said, you got to be aware of mitigating circumstances. You've got to be aware of some of these other things. So in your evaluation report on your eligibility form, you need to make some kind of indication that there is an impairment. This child does have a disability. At this point in time, no accommodations are necessary. However, situations change, we'll review it. Or here are the accommodations he may need if his circumstances change, and you can describe them. Some kind of system for that. But the requirement for a written plan is based on the fact that there is a current disability or impairment, and it does substantially limit a major life activity. Then you must call it a 504 plan based on your evaluation and write the necessary accommodations. Here are some of the things that come up when we're dealing with this 504 plan. This should not be the consolation prize. This should not find yourself saying, well, he's not qualifying for special ed under IDEA, but we can always do a 504 plan. No, not without eligibility fully determined. A 504 plan, or special education for that matter, is not meant to solve the problems of the general education program. He needs help. Have you heard that frequently? Yes. And I frequently want to say back to the general ed classroom teacher, then help him. You know, don't try to send him somewhere else. Just adjust your programming. If there is no disability, he doesn't go somewhere else. He's the general education's responsibility. And a 504 plan is not to be given because parents want something special for their child or because they don't want an IEP. What's inherent here is the fact that if they are eligible under IDEA, that's where they are served. Placement in little buses can certainly be negotiated as part of that arrangement. The criteria base is not, I could get a 27 on the ACT. It's, how am I going to do in regards to everybody else? It's not to make me do better. It is not an instruction-based program. It is to keep discrimination from happening to me. We have created a large arena of multiple problems with this whole concept of extended time. particularly since we have gone into the required testing program and the ACT and all of these kinds of things for our students. And sometimes we can't control. We don't control accommodations on the ACT. Having a 504 plan is not going to get it for a kid because we're not in charge. Regardless of Gloria's comments that the board's not going to accept that if that's a recent addition to the child's career, it's not appropriate and the ACT may not accept it. So we can't fix that situation. The way we fix that situation is through our educational programming. The whole purpose of 504, and everyone has a difficult time in understanding this, but especially do parents who think that 504 is a junior IEP. And sometimes much education and training needs to go on at those meetings. I'm going to do a little bit of a side here because somebody asked me this question earlier. How do we prepare for the meeting when we know the parent's going to bring an advocate? I would hope your preparation is as thorough as it would be without that advocate. And I personally always welcomed anyone that the parent wanted to bring. It's kind of like the doctor's statements that you get. You take them and you consider them and you look at them, but you don't have to do what they say. The prime word is consider. We all know that, and I have had many, many positive experiences with parent advocates. And we all know we have negative experiences in every arena of our life, and there's some in that one too. But basically, my thought has always been to prepare and to get additional support lined up if I think I'm going to need it. In my role as Assistant Superintendent and Director of Special Education in my district, I was frequently invited into a meeting where that kind of thing was going to happen just to provide support and backup, and somebody else that could quote law as good as the advocate could, you know. So get your support, have your pre-meeting perhaps, we're allowed to do that, you know, and be sure that everybody on the school staff is on the same page and has all the information upon which to make a decision. Do not make a decision. Decision is made in the meeting in accordance with your procedures, which includes the parent who is invited. As I say, get your support ready, whether that's the asking of questions, the gathering of information, whatever is necessary, and prepare for a meeting as you would for any child at any point in time, because we want to have all of the information that's necessary. And if you get in a meeting like that and you don't have all of the information that's necessary, you say, we're going to adjourn, we'll meet back next Tuesday at 4 p.m., and in the meantime, we're going to gather this information, whether it be observing the child in the classroom or whatever. I will caution you that it is never appropriate to say, well, I don't know what to do right now, give me a week to figure it out. No. You know, or you say you're going to get more information. Those are the only two options that you have. And you make a decision in that meeting as a team, looking at all the information that you have. So when accommodations are required, these are the standards. Access to an education is going to be equal to that of the education offered to the non-disabled. And the opportunity to participate in all school activities, assessments, non-academics, extracurricular, after-school programs operated by another agency, whatever. The whole big picture is the need for accommodations. Just keep in mind, this is not a chance for the student to do the best they can possibly do. That's not what Section 504 is. Section 504 is equal opportunity, the chance to access all services and do as well as the average student in the general population. 504 is not designed to have better test scores in your building. 504 is not intended to fill mothers' dreams of the student being a cheerleader or making the ACT 27 or whatever. Let's talk for a little bit now about major problems that I see, and some of them have already come up in the conversation. These are the kinds of things I see when I train in schools or when I look at systems that school districts have in place. And keep in mind the thing that I told you much earlier, if you must implement your programming as indicated in your procedures. Errors. You ignore the cause of the problem and just focus on the symptoms. Well, he misses so much school. That's bound to be an impact. Well, that's true. But is missing school caused by a disability? It may be caused by the simple fact that it's a third grade student who can't get himself up to meet the bus and doesn't have a parent in the home who is conscious to get him up for breakfast. I actually had that situation once, and I bought the little kid an alarm clock because he hated to miss school. But he couldn't get there if he missed the bus, and sometimes he didn't wake up. Impairment equals eligibility. No, it doesn't. Neither does a disability under IDEA mean he gets an IEP. There's that second standard, substantial limitation for 504 or adverse effect on education for an IEP. And the parent who requests a referral says, I'll bring all the evaluation information that I have. Great, wonderful. But help them to understand we still have to conduct an evaluation that addresses the performance of the child in the school setting. And frequently, the two seem to not meet. The parent sees things at home that we don't see in school. Or the reverse of that, we see behaviors in school that the parent does not see at home. Well, you may have to address the particulars of each circumstance to explain that. But for the young child who's in a large group setting for the first time having to deal with rules and procedures, he's faced with a circumstance that's quite different from being the only child at home who gets everything at the drop of a hat. And so the two settings are different. It's not that anybody's wrong, it's just the settings are different, and that accounts for some of the difficulty. Here's that psychic hotline example we had a minute ago. I know he's going to have problems next year when he gets to that big old bad high school. Well, we have procedures in place to address that. And it needs to be dealt with in that setting. We don't have any evidence of that problem at this point in time, so there's no way to evaluate the presence of a disability. You must have a current disability that substantially limits right now. And many of those problems that are anticipated at the high school are problems that should be addressed and solved by the general education program, not problems that are caused by a disability. These major life activity areas are unique and separate. And we're a little bit thrown off by the fact that concentration and reading and learning, all of these are in the law now. And any one of those things might or might not manifest themselves in poor grades. Poor grades are not the only criteria, nor are they a requirement of any kind. You have to look at the whole arena of major life activities and the whole concept of substantial limitation. this one, he's capable of making much higher grades. That's in the same category of he can make it a 27 on the ACT if you just give him more time. The comparison base is never the individual child. And this is very hard for parents to understand because their whole focus and their whole world, as it should be, is their individual child. And anyone who has ever had a child or been around children in the family know that you want the very best for that child. And this is not a problem, it's a reality. But it is our responsibility to help the parents and the teachers see that what the focus of this law is the same chance as everybody else, the same opportunity, not the end result. Not that she gets to be a cheerleader, not that she gets to make the ACT 27, not, that she's in the Honor Society. The end result is not the standard. The standard is I have the same opportunity as everybody else. And the system, the program, does not put up barriers to me because I happen to have a disability. Okay, that was some of the eligibility problems. What are some of the implementation problems? Let's say you've got the plan. What are some of the implementation problems where we see errors and difficulties arise? The first one is using 504 for a remedial plan. 504 is not meant to solve the problems of general ed. It's not that kind of a plan. And this can't be emphasized enough. It is grounded in the concept of a disability. And this whole area of accommodations, you can go online and find lists that are pages long of all the possible accommodations that could be provided for a child. And sometimes we get presented with lists like that, saying, yeah, I want these. It's our responsibility to see, just as we do with an IEP, that the accommodations go right through the plan and back to the evaluation data that substantiated the disability in the first place, and go to and speak to the major life activity area that we have identified. We were speaking earlier of the plan that's lost and nobody knows where it is. This can happen between school districts. All too often, the school secretary is responsible for sending the plan when a child moves or when they send records to another building. And sometimes all the information on a child's not in one place. So the plan doesn't get transferred. Sometimes plans do not appear in the next setting because the parent and or child have decided that they want to give the child a fresh start. And so they don't share all the information. I kind of put that in the same category with the teacher, the new teacher for a child who says, I'm not going to read those IEPs or those 504 plans until later in the year. I want to get my own impressions of the child. No. Use all the information that is available to help every child that you're responsible for. That should be the first thing on your list when school starts, is to be sure you've got all those plans and you read them and you get them up here so that you can implement them. I frequently have the question, how can you end the 504 plan? Or how can you change it? Same way it was created. You have an evaluation and you make those changes. You don't have to wait until some particular time that's designated for reviewing plans, particularly if it's a new student in your building or in your school system. You can do that anytime you feel that it's necessary and appropriate, particularly if you get accommodations that don't quite seem to fit the need. One of the first years I was in a public school as a school counselor, I got a plan that required swimming instruction for gross motor skill development. We didn't have a pool in the district. It was in Warren County, and there was a pool at Western, an indoor pool. But, you know, that's a little far out. Aren't there other ways to implement gross motor instruction? So we called a meeting and we discussed the fact, and you sometimes have to be a little creative. I talked about the fact that if we implemented it as written, it would require at least 2 hours out of the child's instructional day in terms of all of the other activities, including recess, that the child would have to miss while we transported him to Western and, you know, changed the clothes, got the swimming instruction, and brought him back. I even threw in the fact that I was a qualified Red Cross water safety instructor, and I could provide the instruction. That wasn't the problem for us. The problem was how much else the child would miss in the school day. And, you know, everybody agreed, parent included, that that probably wasn't a good idea, so what else could we do for gross motor development? And we came up with various solutions that we put in the plan. Teacher that wrote that plan, by the way, had left the school district the previous year, was no longer there. Plan is lost, be sure that you have a system in place. And Gloria has described for you that you get a list in your building every school year, beginning of the year, of who has those plans, and you can track them down. Termination of a 504 must be done with a reevaluation that you can do at any time. And we mentioned earlier the failure to review. The law calls for periodic review. We're told that we can implement that part of the law in the same way we implement IDEA. And of course, there's a requirement for 3-year reevaluation in that law. This evaluation under 504 is substantially different from that, as we've talked about, so you can do that at any point in time. And please review those plans, see that they are current and that they are applicable, particularly in the accommodations that are necessary. Okay, we've talked about eligibility issues and implementation issues. What are the commonplace compliance issues that OCR finds across the country and that hearing officers run into from time to time? And I am a Section 504 hearing officer at the current time. I have been an IDEA hearing officer, but that stopped. So what do we find? You develop a plan and you don't have appropriate evaluation. Or you lift accommodations out of the air that have nothing to do with the evaluation that you developed. Or the things that the team said needed to be done just aren't being done. There's a classic case on the books of a high school history teacher who simply refused to implement the accommodations for a student in their classroom. And outcome was he had to pay a hefty court fee and fine for that. Failure to refuse or refusal to consider evaluations by outside professionals. This does not say implement. It says consider. Consider is a very powerful word, both in 504 and IDEA. You need to receive those reports with much appreciation and thank you. Not require them, but receive them when the parent presents them. You need to tell the parent that you would certainly be willing to consider any information they want to contribute to the discussions. And we all know that sometimes those reports are extremely helpful and sometimes they are not. They do not ever, ever take the place of the school system doing their evaluation. And we must consider them and have that documentation. Received report from, and it's discussed and addressed at the meeting. Fixed limitations on home hospital. The state does this. I don't know what the current standard is, but there's so many days, 2 days a week. That cannot be the stopping place for an IEP or a 504 plan. If the student needs more home instruction than that, that is a decision of the team, and you will make it. And part of that expense might come directly to the school agency in some way rather than reimbursed by the state, but that's all right, has to be. Failure to transfer the documents, we've discussed that. The I didn't get it will not suffice at hearing, I promise you. And another issue is the failure to review the plan and evaluate it before a change in placement. Change in placement does not simply mean to a more restricted environment. It might simply mean from elementary to middle. So it will behoove you to pay close attention to those new plans that you receive. Here's some more issues that we see that develop into compliance issues. Mom comes in and says, you know, I don't know what's wrong with Johnny, but it's not right. He's just not doing like he ought to do. You need some help. What can we do? That should trigger in your mind a referral. Don't say, well, we're doing everything possible, or we're watching the situation, or, you know, we don't see any need for that at this time. Who makes those decisions? The team. The psychologist, the counselor does not do a screening and say there's no indication of a disability at this point in time. You can do the screening to guide you in a further evaluation, but you can't use the screening to stop an evaluation. Better part of valor is to accept a referral and evaluate the entire situation. Failure to implement the plan in the regular education setting. We've discussed that high school history teacher who said, no, just not going to do it. Or the school secretary who said, he's got to come to me if he wants his medication. Just not appropriate. You're wrong. Exclusion limitation on participation in electives, field trips, extracurricular. We have discussed that already today. You know that if they need accommodation, supports, and services that are provided in school by the school, they will be provided outside the school setting for these kinds of activities. The question was regarding timelines, and the law does say timely, and that does not provide for a 6 months kind of a period of making up your mind. It is timely. It is doing something now. You have a concern, you must deal with it. Begin the process and document. There are so many issues, so many areas of concern, but our overriding focus should be to meet the needs of every child in our building, as well as we meet the needs of all children. And we should have an attitude of willingness and openness to work with community agencies, with other professionals, with parents, with grandparents, whoever might present as having concerns about a child. They may not know the words to use to request an evaluation, but we can tell their frustration. We can tell that they need something, so we should respond with empathy and concern and willingness to investigate the situation. So this circle is quite a bit more detailed than the first one I presented to you in terms of a graphic. You'll see that in the very center, again, we have section 504 only, and that is generally 1% of the student population, of the total population. Around that, we have IDEA/504, because if you have an IEP, you also have to include the non-discrimination because of a disability needs of the child. The next circle, we have a situation of a disability, but they're not eligible and there's no plan. How can that be? Well, in IDEA, there's no adverse effect on education. And if you've gone that route first and made that determination, then you must also consider whether there would be some remaining needs or concerns that might be addressed by a 504 plan. Not automatic, but consider. But if there is no adverse effect and there is no substantial limitation, there can be a disability with no plan, but that gets kind of shaky in terms of evaluating section 504. We know that if there's no current disability, there's no plan, and that just because they did have a disability, just because they were remediated and released from an IEP, doesn't mean that they have one now, because they have a record, or because I think they might have one, like the coach in the example I gave you about denying the kid football practice without a medical statement. But you really just don't see it. At the bottom of this chart, we're trying to address the concept of a current disability but mitigating circumstances, or a current disability that's in remission or episodic in nature. And if there is the disability that is present without consideration of the mitigating circumstances, of the episodic, of the remission kinds of things, a plan is not required per se, but they get the protections under 504 because they still have a disability. It didn't go away. It's there, it's masked so that no accommodations are needed. So in that case, while you might not have the same form and the same plan, you need something, as we discussed earlier, to indicate to individuals in the school setting that this is an individual with a disability. And when problems arise or circumstances change, that disability needs to be considered. And the examples we gave of that were the manifestation determination in terms of discipline areas, the accommodations that might be necessary for episodic homebound or various things like that, various accommodations. Districts are allowed to do that in a variety of ways, and you have a procedure in your district where you indicate on the specific form, no plan, no accommodations are needed at this time. And we've also discussed the fact that you can go ahead and write the plan and specify what accommodations would be needed under certain circumstances, like when the disability is no longer in remission. This has been the major difficulty of adjustment for schools, I think, Gloria, in terms of 504 planning, because we're frustrated by the fact that the Ritalin is fixing the problem. And so I don't see it. So how do I know it's there? That's because you do an evaluation and you make that determination. And then what do I do when it's not there? What do I do when the medication's not in place? What do I do? You write those accommodations and you have a procedure for implementing them when needed. I generally don't like that phrase, when needed, when it's left to teacher discretion. I like the phrase when needed when it applies to the evidence of the impact of the disability. And there's a big distinction there. So tie the accommodations needed back to the disability impact itself. You, the school team, must make a decision. You make the best decision that you can. You follow the forms and the procedures that are presented to you in the Jefferson County 504 manual. But you can't sit there and say, oh golly, I don't know. Oh golly, I don't know is not legally defensible, nor is it morally defensible for a child.
With regards to the service animal that you spoke about previously, does the school have any do we need to meet any requirements for that dog, for that animal? Like, do we need to provide a space for them? Do we need to then do a schedule of potties and food?
Our question is what's your responsibility towards the service animal? Allowing it to be at work in your building. You do not have to clean up after it. You do not have to provide it food. You have to allow it to have food, allow it to have water if that's appropriate. But we are not in the care of animals business.
But thinking about, I'm in an elementary school, I wouldn't feel the time for my
Excuse me just a minute. Let me thank all of you for being here. I know you have schedules to make and places to go. I'm going to be here and Gloria's going to be here and we'll continue to answer your questions.